All right. Good afternoon, everyone, and welcome to another edition of Fire Law Roundup. Brad, I'm going to turn it right over to you, but Fire Law Roundup, April 18th, 2022.
Fantastic. Today is kind of a light day, so I wanted to, when we get to some of the cases, the first and the second one, focus on some really good things. Some of it's like law school, some of it highlights some things you and I have talked about a lot. But so since there's not a lot of really complicated stuff this week, we can kind of slow down and focus on certain things. So let's start with this. So we have a case in Alabama where a court ruled against a firefighter's discrimination suit. And basically, an individual, I'm going to make this very simple facts because this is so universal to so many issues. He basically said, look, I was qualified for a position and you didn't give it to me. And the facts are that he was actually disabled out of the line of duty. It sounds like a temporary permanent disability. And I think maybe with regard to a military service, and he couldn't fulfill the essential job requirements of his position. Ultimately, what happens, and I don't need to say much more about the case, but we need to talk about why there was a victory and how little things could have changed that victory to a big loss. So the court looked and said, listen, you claim you were discriminated against in terms of promotion and your job and your reassignment. And the fact is you couldn't fulfill the essential job requirements. So they kicked the case. And it's a solid defense to a discrimination claim if you can't fulfill the essential job requirements. But let me go out on a podium or a pedestal for the second. First, this department had written essential job performance requirements. If you don't have them, you are so likely to lose one of these lawsuits, because you can't say you have essential job requirements, which they can't meet. And the argument, well, everybody knows what a firefighter has to do is not true. That is not a defense. Two, what I always see happening, and I probably have this conversation with clients no fewer than one time a week, and I'm not exaggerating, what I always see happening is, we send our firefighters to an occupational health group and they do the examination. I said, that's fine. I said, under what standard? And they said, their standard. Like, no, this is a non-delegable, what we call in the law, non-delegable duty to create this standard. You cannot say it's whatever Dr. Smith on any given day says are the job requirements. You have to create the job requirements. For example, in Ithaca, New York, where we have Cornell University and rappelling and rope rescue is a big thing, they may have very different job requirements for some positions than would rural search and rescue fire department. One size doesn't fit all. So you can't possibly rely on the doctor. Now, the second thing I have is the doctors say, we do a 1582, an NFPA 1582 physical. And I always ask, well, do you get a colonoscopy? And they're like, no. I said, okay, so you're not getting a 1582 physical. Once you take one thing out of the 1582 physical, it's not a 1582 physical, right? And so you have to have your own written standards with essential job functions or job performance requirements. You have to have, I like what NFPA 1582 does with their category A and category B. Now, and again, remember, people, that 1582 is an entry level, right, physical, but I've converted it many times to a re-entry or a return.
Yeah, I think it is. I think it is. It has two components. It's both initial and what do you call it? A reoccur. What's the name for that? I forget the name.
Return to, isn't it? Right?
Well, it's just an annual, the annual incumbent, an entry level and an incumbent,
And the problem, though, is just strictly saying each is because the category A exclusions, for example, you have type 1 diabetes, you are not going to be able to get a job if you adhere to the 1582 standard as a firefighter. However, when you've already held the job, simply developing a category A prohibition type disease or symptom or whatever isn't necessarily going to have that same effect of saying you're fired.
Yeah, but there's a lot in there. And when I was with the NFPA, I was dealing with the legal department on this quite a bit. The NFPA cannot override the Americans with Disabilities Act. And so if someone with diabetes, just use that as an example, if someone with diabetes can perform the essential functions, then regardless of what NFPA 1582 says, you cannot discriminate against them. You can't just say this is category A, therefore we don't have to hire you. You have to, basically the person is going to show that they can perform the essential functions. You've got to somehow either show they can't or show that there's some sort of legitimate reason why, risk or, what they call actual harm or actual threat, real threat. But you can't just wave the category A flag. And that's an important misunderstanding up there. But there's one more thing about that case, about the Alabama case, I think is really interesting. And it's a good model for other fire departments to use. At the time, they had a number of administrative captains positions. So as I would imagine, that they're non-line captain administrative type positions. They got a new chief in right around the time that this was all transitioning. When this firefighter came back from the military, he was injured apparently in combat, and he wasn't able to perform as a firefighter. So they kind of stuck him in one of these administrative positions. New chief comes in and says, we need to get more people on the trucks. We need to eliminate these positions. And so there was a question about, was that discrimination? And the court said no, that this was a legitimate strategic decision by the department to start phasing out these administrative positions. It was not directed at this person because of their race or because of their military
or disability.
Disability, or because he had filed a claim under USERRA, the military discrimination law. And they said that they had a legitimate reason for implementing this. Basically, everyone, they used the metaphor to the Marines that everyone is a rifleman. I guess you call it a rifle person today, but everyone from the commandant on down in the Marines has to be proficient at shooting, because you may have to. And the new chief said, this is how we're going to approach operational type duties in the fire department, that we've got to have plug and play people, that anyone, myself included as the chief, everyone has got to be able to perform these functions. And if you can't, temporarily we can, put you on sick leave or light duty, but you can't permanently remain in these administrative positions. So the court upheld a pretty good decision, I think, overall, in explaining.
Again, this could have gone very badly for the fire department with lack of policies. If you don't have policies, you're losing.
Absolutely. Absolutely.
Okay, the next one
but the reason I say that is there are departments out there that feel the need to, like, they make an exception for one person who's got light duty, then they make another one, then they make another one. Next thing you know, you've got more people sitting around shuffling papers at headquarters and not enough on the trucks. You're paying overtime, and they've got to figure out, what do we do about this? This case sort of provides a blueprint for a solution to that.
Right. And I got to tell you, light duty, we could spend hours talking about light duty. I hated light duty as a chief, because what happens to you is you get accused of, well, why did you give light duty to this person and not that person? Right. And, it's an all or nothing type thing.
It's funny. We used to refer to light duty as lords. It's like the French fountain there, that you go there and all of a sudden you're all better because you're sitting at home for 3 or 4 months recuperating. All of a sudden now you got to come to work every day, and like, the heck with that. I might as well just go back to my regular assignment. So,
yeah, well, that's why the employer sometimes is the chief. Right. I hated it. I just, everyone said, well, why did this person get it? Why didn't that person get it? Why didn't I get it? Like, okay.
I got you.
Okay, the next one is a great time for us to go back to first-year law school, although not really first-year law school, because the courts can't fully explain this next concept in a good way. So look, I'm just going to make this really simple, and I'm going to try to do a little law school 101, and then Curt and I can jump all over this. So basically it's a grade 2. You got a patient who's put in an FDNY ambulance. He's restrained. They have the belts on him. They follow protocol, and the guy undoes the belts and jumps out and, gets injured and sues the fire department.
Yeah, while the ambulance is moving, he jumps out.
Oh, yeah. I mean, look, crazy.
And it's your fault.
Right.
Right.
So
your fault I jumped out of your ambulance.
Yeah. Just the amazing thing is he gets a lawyer, right? Who, I mean, look, you've got people are probably thinking assumption of risk or whatever, but this case is important for us for one bigger reason, because it's a great teaching point. And it really is a great teaching case for us. So I want to explain that the court here goes through a very common, I know it's in your book, and we whenever we teach, we talk about this stuff, but it's a very common analysis. And so let me kind of step back a little bit and explain, and you even have a note on your blog, Curt, even though the court didn't discuss one of these concepts, they could have, and probably also maybe
should have,
right? I would be both. But okay, so here's basically what it is. Let me give the overview, and then we can discuss the case more in depth. But there are two types of analysis when I'm not even doing this well. There's an analysis when you look at whether a government entity or a government actor was negligent. It's much harder in most cases to win a lawsuit against a government entity who does government acts, I'll explain that, than it is to sue a private person. And the reason for that is what we used to call sovereign immunity, where the government, both federal and each of the states, have all said, listen, we don't have to allow you to sue us. The government can be immune, right? You can't sue the king, sovereign immunity. But you can sue us if we tell you that you can sue us for certain things. And so the governments, I can't say every state, Louisiana is probably a little different, but generally the government has said, we'll allow you to sue us for certain things if you can establish certain prerequisites. And so the first question the government looks at is, listen, was the action that the government entity, let's say the FDNY, right, undertook, was that a governmental function or is that a proprietary function? Now, let me explain. So the better way of saying it is, was it a function that's normally performed by government entities, or is it a function that's normally performed by private entities? And that alone is a huge division in the courts. Even this court, the New York court, which cited a much more famous case, which I could talk about, but the courts all disagree in New York. They probably all disagree elsewhere on what necessarily is governmental versus private, right? What type of action is a government function versus a private function? For example, most fire departments, maybe not in Arizona, right, where rural metro is, but most fire departments are only provided by government entities or quasi-governmental entities, those who contract for or controlled by. So fire protection is generally a function only provided by government entities. Not all universally true, of course, but in most cases. Ambulance protection is a much harder question, right? Because there are definitely private ambulance services and public ambulance services. This court starts out, and these courts generally agree that where the government is providing the ambulance service, it is a governmental function. But again, we cannot say that ambulance service is always government because, again, it's certainly a private function. So here we're just going to focus on governmental because this case said when the FDNY provides, or the city of Newark provides a ambulance service, it's done as a government function. And the cases in that regard are pretty much universal. But look, I'll give you some examples. There are splits in cases on whether maintaining fire hydrants is government or private. There are all sorts of different decisions. Not any have one clear state of mind where you could say, oh, here's the absolute bright line test. You can't. So it's not 100%. Fire protection usually is governmental, at least in most states, not all states, but ambulance protection is not. This was
I think particularly where you're dispatched to an emergency. And I know there's some fire departments out there that do inter-facility transports. They do it They actually do. I know it's
Good point. Good point.
yeah. So I think if you're doing an interfacility transport, I think you may find yourself in a different situation. This was clearly an emergency dispatch. So
and wellness checks is another good example. Wellness checks are not universally governmental, right? So even though you do a wellness check with an ambulance, the ambulance function of providing a wellness check may be private, maybe, right? Something a private entity does and not a government entity, because that isn't normally what the government. So there's this issue is so hard, and the best a lot of times you get, it's a roll of dice crapshoot. It's a tough issue, but okay. Why do I say that? Because once you determine that what you're providing is a governmental function, there are two significant protections, at least two, there are really more, that are given to the government who's the defendant in the suit, right? So first, you could do this one of two ways. I guess it doesn't really matter, but first, in order to prove any negligence claim, we know there are four tests that you have to establish, you have to pass before, four components of a negligence lawsuit, which isn't even the right way of saying it. Negligence lawsuit. That's an unintentional tort, if you want to get it right, right? Oh, an unintentional wrongful act lawsuit. That's how we should talk about these, as unintentional wrongful acts. Negligence is a culpable conduct. That's not the right way to say it. Okay, so here's how it works. So we know that against any unintentional lawsuit, right? For an unintentional act lawsuit, you have to prove that the person who injured you owed you a duty, and that they breached their duty by whatever they did, and their breach of their duty to you was the direct cause of your injury, and you had injuries. Now, all we're going to talk about today, we could do this right for a semester. All we're going to talk about today is, did they owe you a duty? Well, for a governmental function, the cases fairly universally say, listen, when the government performs a governmental function, they owe you and everybody else the same duty. So when they don't do something that they were supposed to do, they don't have any liability to you, the individual, because they had to provide fire protection, police protection, ambulance protection to everybody. So they didn't owe you that duty. They owed everybody that duty, and no liability for breaching a general duty. Unless the courts say, and in New York State, the big case is Cuffey versus City of New York, but there's a lot of these cases, unless the government or the plaintiff who's suing the government can show, listen, I agree you have a general duty, but in this case, you formed a special relationship with me, creating a special duty. And if the plaintiff can prove the government owed them a special duty, a heightened duty, then they can continue on to the next question, which we're going to get to, because this court here actually skipped that and then went to the second question. And in New York, we always do special duty first, and then we do the second one, except this case, which did in reverse for some reason. In any event, so here's how you prove a special duty. It's very simple. It's not simple, but I can explain it, I think, simply. It basically says, listen, you and I, me, the firefighter, let's say, or I'll do it in this case, me, the paramedic, and you, the patient, we had a one-on-one relationship. We directly communicated. Two, I said or did something which caused you to rely on me, and you had the right to rely on me. You relied on me to your detriment, meaning you relied on me and I didn't do what I said I was going to do, or it didn't turn out the way I said it was going to turn out, and you were injured as a result, right? You relied to your detriment. That's a special duty. And let me give you a simple example. I pull up on a scene of a structure fire. You're in the second story window. I look up and I say, don't jump, I'm coming right up. Stay right there. And you're yelling down, but I'm burning. It's really hot. And I'm like, don't jump, I'll be right there. And I go out and get some donuts instead, right? And you die because you sat there waiting for me. That's a one-on-one relationship where you relied on me to come and get you. I didn't get you. You died as a result, right? You relied on me to your detriment. I think, unless you have another way you want to explain special duty.
That's a good one. There's actually one in New York. It's a little bit different. The Stata case. I don't know if you're familiar with Stata, but basically a guy and his wife wake up. The place is on fire. They make a plan. They're going to run out of the building. The man gets out. The woman doesn't. He goes back in. He's not able to get back in the apartment, but he goes to an adjoining apartment, tries to breach the wall, and he's working on breaching the wall to reach his wife. And that's when the fire department gets there. And again, this is according to the case, so that the facts the facts may, but the bottom line is he's trying to breach the wall. The fire department gets there. They drag him kicking and screaming out of the apartment saying, we'll get her, we'll get her, we'll get her. He looks back, sees that the fire department is not going to get her, grabs equipment off the truck, starts trying to go back in. They grab him a second time, basically with the police, hold him down, and we'll get her. And nobody went and got her.
And
So,
it's interesting. So the reason I'm not familiar with the case, but the reason that case is where I took my facts, but I made a significant change because I actually don't agree with that case. Remember the first element of special duty.
The court didn't say the special duty applied. They said it was going to be up to a jury to determine if the special duty applied. So that's.
Yeah. But here's what's missing. And I actually had a real case like this when I worked in the Court of Claims, the state court system where, these types of cases go. But the problem is there wasn't one-on-one contact, right? The intervening person was the fire department, government, and the husband. The wife never directly relied on the government, right? The husband relied on the government. That should have terminated the special duty rule because there wasn't one-on-one reliance. There are cases, and I had a real one, not to get off topic, but I had a real one where, and it just happened again, it'll be interesting to see what happens, where social services, somebody kept calling social services saying that baby's being abused, the baby's being abused, and they kept telling the person, we'll look into it. They didn't, and the baby dies as a result, and so the baby's estate sues, and they had to get past special duty, and the question was, well, the baby didn't rely on anything. But
there's another one I got in my book, the Odie case, which is the Odie, Gary versus Odie versus Gary, Indiana. It was an Indiana case. It's the leading case, really good case, but it was a wife calls for her husband who's having a heart attack, and they said the trucks are coming. Well, the trucks didn't come. It took them 45 minutes to get there, and they could have loaded him in the car and driven him. He was only like 5 minutes from a hospital. Her son was there. They could have loaded him in the car. So again, I think we're getting kind of sidetracked, and I apologize for getting
because it's interesting. In a case I'm going to refer to called Lynch v. Town of Greenberg, those are the facts, except it's an ambulance case where the BLS ambulance could have taken her and said, no, we'll wait for an ALS ambulance instead, and suffers cardiac arrest in the interim. And they waited 20 minutes, same exact case, except it fits this case here. I tried to find a case that worked, and Lynch v. Greenberg is a great case because anyway, so let me just finish up. So if you get past special duty, and again, this case we're going to talk about kind of does it in reverse halfway, then once you establish that there is a special duty, then the courts look at and say, okay, wait a minute. If the act that you actually performed was a discretionary act, where in performing the act, you could exercise judgment, then as a governmental actor, you're not liable because there could have been different outcomes if in performing the act. So, and let me explain that. You can't just say, well, all ambulance service is discretionary. It's not. The act may be a certain act within providing ambulance services discretionary, and that is the act specifically. If that's the act that harms somebody, that's the act that has to be discretionary to get you out of the suit. So if it's a discretionary act and it makes sense, you can't be liable. For example, in the fire world, as we all know, how you fight a fire is almost always discretionary. However, and I wrote an article on this a long time ago because it was a case against my neighboring department. The court held NIMS, right? Who'd have thought NIMS? NIMS has 4 non-discretionary components, and it's state and federal law in every single state across the nation, and it's federal law. You have to follow NIMS. So if you violate one of the 4 mandatory components of NIMS, it's not a discretionary act, it's liable. So that's a good example to say, look, how you fight a fire is generally discretionary. In this case that I'm talking about, in the NIMS case, it was one of the people failed to check in and was freelancing, which is one of the 4 mandatory non-discretionary components. And the act they said hurt the person was because somebody was freelancing on scene and was giving orders outside the chain of command. That's a good example in the fire side of, just a generally discretionary act of fighting fires, but the exact act was not discretionary. So here, and we're going to focus on this case, but I really like this case just because we could talk about.
I can tell.
Right. Well, it's a big deal for people. Anyway, if it's non-discretionary, you lose. If the law said you had to do X and you did Y, you're done, right? So here, look, they jump over special duty. They just go to whether this is discretionary or not. I think they got it in reverse, but they wanted to jump. I don't know. I thought special duty can be, as you said, a jury question. So they didn't want to say, let's leave it to a jury. So maybe that's why they just said, no matter what the jury decides, this was a discretionary act, or and frankly, he was seatbelted improperly. They didn't do anything wrong. You could have hit this a whole bunch of different ways to throw this out. Yeah. They followed protocol, and he assumed the risk. He got out. For whatever reason, he unbelted himself and jumped out moving an ambulance. But I don't want to beat this up anymore, other than say it's a great time to talk about special duty and discretionary act immunity.
Yeah, and I mean, you and I approach this differently, and that's interesting. I was listening to you explain it, because in my mind, the idea of sovereign immunity exists where government has to engage in a discretionary act, and it doesn't exist where government is carrying out an act. And that makes a lot of sense, because otherwise we would be second guessed on a lot of things that we shouldn't be second guessed on. Now, for example, whether or not an engine is going to proceed through a red light is a functionary act. That's not a policy setting. Discretion to me means you're setting policy. For example, how many EMS units is the city of New York going to have on duty? Are they going to have 2 paramedics or 1 paramedic and an EMT? And on all of those discretionary types of things, how many firehouses are they going to have 1 EMS unit in a firehouse or 2 EMS units in a fire? Like all of those things, you could get second guessed to death. On the fire side, okay, are you going to have an aerial ladder at a certain station? Is it going to have an 85-foot stick, a 95-foot stick? Is it going to have a 95-foot tower or a 95-foot stick? Is it going to have 110? And the reason there is, if you say we're going to have 110 rear mount ladder, and someone dies because you didn't have 106 foot, or 120 foot or 130 foot or whatever, you could get second guessed to death. So the idea is, when government is acting in a policy setting way, there's sovereign immunity. When government is carrying out policy, it's functionary, it's ministerial, and you don't have the benefit. Now, you still have the benefit of other defenses, but you don't have the benefit. And it seemed to me that the court was sort of abandoning that and just saying, well, this is discretionary. And the reason why it drew my attention is because if you follow the court's interpretation of discretion, then virtually every decision that someone makes could be discretionary. What foot I put in my bunker pants first is an act of discretion, because I'm making a discretionary. I'm going to put my left foot in first. I'm going to put my right foot in first. And I think that the better rule is to step away from that. When government is policy setting, then we have immunity. When you're carrying out policy, for example, you're driving a truck through an intersection, you're not setting policy when you're driving a truck. When you're administering first aid to someone, you're not setting policy. Therefore, that's ministerial. But again, in New York, every court and every state looks at it a little bit differently. And I think you gave a pretty good example where they don't recognize that distinction that I did. They're actually getting down into the 4 elements of negligence. And that's how they reach that discretionary act. So that's interesting. But we spent quite a bit of time on that, and I apologize. I sidetracked you on that.
I mean, look, we always hope that our viewers get something more, get the education out of this, right?
And we don't want them falling asleep in the chair either. So
good point.
Right.
Good point. So from here, look, everything's pretty quick. There was a Virginia firefighter who was convicted, and the conviction was upheld. I've never seen anything like this. Have you?
Did you? No. I was talking to my brother yesterday. We had Easter dinner or Easter brunch over at his house. And, Jeff's a fire chief. And I said, yeah, do you believe this? And let me ask you something. The statute. Now, we have a firefighter, just to lay out the facts here. We have a firefighter who he's apparently a career firefighter in this Virginia Fire Department. And his driver's license lapsed. So he's terminated. Okay. And then he goes and gets And this whole
Well, he then signs up, I think, as a volunteer.
he does, but he gets his driver's license a day later, but he doesn't ask for his job back. He says, okay, I'm just going to be a volunteer. So now he's a volunteer. Okay, so this all happens over the course of about a month, but now he's a volunteer. And apparently in this department, if you're not a paid firefighter, you can't drive the trucks. So now there's a dispatch for a structure fire or whatever, and he gets to the station with 2 other volunteers, and he decides he's going to drive the truck.
And so, whether it matters, he's first
apparently he made kind of a rookie mistake, but whatever, he left the compartment door open, and it also said, the case said that he backed out of the station, which I thought was really kind of bizarre. But at any rate, he's charged with stealing the truck. He's charged criminally, not with a rule violation. He's charged criminally. Now, did you look? I don't know if you looked at the statute, Brad, but to me, and I didn't want to put this in the article when I blogged about it, it looks like the joyriding statute, what we call here joyriding, is when you take a vehicle, you're not intending to permanently deprive the owner of it, but you're using the vehicle without the owner's permission. So one of the things about larceny, theft, is that you have to intend to permanently deprive someone of the property. And what was happening in the joyriding cases back in the 50s and 60s is people would just jump in somebody's car, take it for a ride, and leave it. And you couldn't prove that they intended to permanently deprive the person of ownership. So here, they charged him under what I call a joyriding statute, and he got convicted.
Unauthorized use. Let me ask you a question, though. The way I interpret the unauthorized use is that he was not authorized by the chief to drive that vehicle.
Right.
So by that means, anybody who does something out of their authorization could be criminally liable, especially when it involves a vehicle. I mean, authorized use, authorized is interesting. It may not be the owner of the vehicle authorized them. I would have thought that it was authorized, but wow, I mean, for criminal, I mean, this.
I mean, it's one thing if I take a fire truck out of the station and not go into a fire, not for the benefit of the fire department. I take that out. Maybe I go to the liquor store to go buy some beer, bring the truck back, and then I go home with the beer. That's one that I think you could make the case for joyriding. He was taking the truck to a fire for the owner's benefit.
You have to imagine there's something more going on where he really pissed off.
Oh, I hope so. I hope so, man. I hope so. I'm flabbergasted by this.
Well, and here's the thing I didn't see, which I wanted to know. Once he arrived, were his services accepted?
Oh, he never arrived.
Oh, he never arrived at the fire?
No, they had an accident at the station, and then right about then they got canceled.
Oh, I thought he kept going.
No.
Okay.
No, you're
So
right. You're right.
time.
You're absolutely right. Yeah, you're absolutely that would have, but no. And I think probably if he didn't hit the station, he did like $20,000 damage. If he hadn't, then maybe they wouldn't have. But I just feel like that's overcharging. I mean, it's just not. I can't believe the prosecutor and the police took the case.
There was something else going on where and look, we don't know, right?
I hope so. I hope there was something else going on, Big.
Okay. Next, we head on to Idaho, home of the best potato growers ever, which I say truthfully because Idaho potatoes.
Maine. I've got to speak up for my friends in Maine.
Oh, well, okay. Well,
Maine's got the
Salt
best
City potatoes. So.
Maine's got the best. Idaho's got second best.
In any event, so you're probably, I'll give you the short facts on this. You're probably better at this than I am, but basically you've got 2 firefighters who are the president and vice president, I think, of their union. And they're trying, I'm going to almost immediately turn this over to you because they're trying to use the right to work law really in a way it wasn't intended, but I think it's very interesting. So I
actually reached out to several labor attorneys on this, and they're all shaking their heads. But for those of you who aren't familiar with right to work laws, the idea behind a right to work law is to protect employees from being forced and coerced to joining unions. So the purpose of right to work is to basically take some of the ability of unions away in terms of their ability to organize and make it a more a more difficult process for the union to collect its dues and maintain its membership. Okay, so it's not to help unions. Okay, so these two Idaho firefighters are alleging that they were being discriminated against by management because of their union activities, and they're suing under the right to work law, and they're saying that's what we would call the preamble to it, which is that 44 2001. And it's in the blog if you take a look at the blog, but it talks about the declaration of the policy. But it says that the right to work shall not be infringed or restricted in any way based on membership in the labor organization. That they're saying that that language actually protects the labor union and doesn't necessarily protect the members from the labor union. And it's an interesting argument. And again, I shared the post with a number of labor attorneys, and they're saying, wow, we got to see where this goes. And I do want to make it, yeah, well, if it was based on the spirit of the law, that would be one thing. But when you look at the language of the law, it seems to offer protection to union elected officials as well, or members of the union. But I do want to offer a caveat to folks from like North Carolina, South Carolina, Alabama, which is really some of the core right to work states. Every right to work law is going to be slightly different in terms of the language. Your right to work law may not have this language in it. This is the Idaho law. Whenever a law goes before, Brad knows more than I do about how the legislature works. I was a House page. I don't know if you knew that, for the Rhode Island legislature for a little bit, but you know, you have these groups lobbying whenever there's a piece of legislation, and sometimes in order to satisfy one constituent group, you have additional language added in and so on. So I would very much doubt the right to work laws in the southern states have this kind of language. And I would imagine this language is in there probably as a compromise. But if you happen to be in a state where you have this language in your right to work law, you may want to stay tuned to this case, because it may turn out that you know, the law actually offers protection to unions. So stay tuned on that one.
Okay, and the next one is also just a lawsuit, right? It's not a decision. The first one is the one he just went over was a lawsuit, not a decision. So this one is the same thing in New Jersey. Now, this is really interesting.
It is.
And I'm surprised it happened. And I'm not saying anything about the fire departments. Again, these are the allegations in a lawsuit. We don't know any of the facts. We don't know what's true. That'll happen. But allegedly, they just, you know, they brought AFFF to a scene and used it, and, you know, inherently contaminated the land. The reason I'm surprised that it's true, or if it's true, there are now thousands of lawsuits probably nationwide on AFFF, tens of thousands, you know, but by firefighters saying they developed cancer or something else as a result of the use of AFFF. Here, the fire department still had it allegedly in 2020, where most places like in New York, and I'm guessing many others, the DEC, Environmental Conservation, reached out and said, get rid of it, give it to us, we'll get rid of it for you, but we need to know if you still have it. And I know some of these fire departments for different reasons. They're good fire departments. These are not, you know, uninformed fire departments, at least some of them. So I don't know whether it's true or not. I don't know how it happened or not. I'm just a little surprised, if it's true, that anybody still used AFFF on a scene. And then, but this is interesting. I haven't seen, you have, if there are, I'm sure, I haven't seen cases by the property owners where they said, well, you knew you should have gotten rid of it and you used it anyway, and now my land is a Superfund site for, you know, that type of thing. So have you seen any of these cases before by the property owner?
Not on this fact. And here's the thing. I did a little bit of research in this because I'm a hazmat tech, and I'm a little bit into the nuances here in recovery for hazmat responses. And as a general rule, if you're a property owner, a business owner, and you bring hazardous materials onto your property, then you're responsible for any sort of problem. Like, let's say you have, I don't know, 500-gallon tanks of a certain toluene or whatever it is, and there's a leak or there's a fire or whatever. Well, you're responsible not only for the leak and the fire, but also for any firefighting efforts or containment efforts that may make it worse. So, like, that's part of your, you chose to bring toluene onto your property. You should have a plan for how you're going to deal with it. You should have a cleanup company and all of that. So I think and I was looking through some of the legislation on this morning and the regulations. The thinking here is it's almost like an economic approach. If you're going to work with toluene or whatever the chemical is, you need to build that expense into the cost that you're going to charge for your product and all that. So it's an economic kind of approach there, okay, which is fine. It makes total sense, okay? So if we had a fire in a facility like that, they applied AFFF, you're going to have to clean it up anyway. You're going to have to clean up the AFFF. Okay, so that makes sense.
And that's a good proximate cause issue. And
right. Now we've got a business that does not have one of those hazardous materials, but interestingly, they do have. It's apparently a auto salvage company. So they have a large number of vehicles, which, vehicles are going to have gasoline, oil, transmission fluid, radiator fluid, and everything else. Also, there's other things that, grease and other things that some of the plastics and different things. So bottom line is, maybe not toxic in the sense that maybe toluene or some of the other really bad stuff is, but nonetheless toxic. But now you have a fire, and now you have something else that's brought in by a third party. And I think this is interesting. I'm not sure if it's a loophole or what, but it's going to be interesting to see how this comes out. But certainly it may speak to the need for fire departments to carry some sort of an endorsement if we're going to continue using AFFF. And we recently purchased some, but they have low PEL. It's
not the carcinogenic version of AFFF.
Well, I don't think you can ever get away from being totally free from those things, but it's much lower, and it's within EPA limits. Okay, so they do make it, but it's much less hazardous than it was 15, 20 years ago. But it still requires, like, if we use AFFF, and at least in our state, you have to notify. We call it DEM, Department of Environmental Management, but it's same as your DEC. But we have to notify them, and they've got to get a contractor in to clean it up. But an interesting issue here in terms of whether or not the fire department, when they bring this into a place where it's not a hazmat site and now we've created it, what is our responsibility there? So it'd be an interesting case.
So we'll follow it. Yeah. That's all I saw in your 5 main posts. I didn't see if there was a Beyond the Blog.
Yeah, there's a couple. Let me see if I can get some of our Beyond the Blog thing. I know we're going kind of long here, and I apologize. Yeah, but a couple of interesting cases, couple of overtime cases. California City has got an FLSA case. Those are on Bill Macarone's blog. I'm not going to go into those other than say, Bill, overtime, whether or not chiefs and captains and lieutenants are eligible for overtime is an ongoing issue in the fire service. Bill is going to have a class a week from this Wednesday on that very issue, on whether or not, and the big battle is mostly on chiefs, but there are some departments where there's a question about captains and lieutenants as well. So Bill's going to cover that, but a couple of cases in there. We've got another very, weekly female sexual harassment lawsuit, settlement of a sexual discrimination lawsuit. Interesting case that was filed in state court out of Nashville with a firefighter who he referred to basically the government of the United States as being illegitimate, and he called the council members white supremacists. And he was disciplined for those remarks, and now he's suing this. I haven't been able to get a copy of the case because it's filed in state court if it gets appealed, but I don't know if it's going to go to federal court because the newspaper article about it says that he's claiming First Amendment. The court proceedings, which I was able to take a look at the docket, basically says it's an appeal of his discipline. So he may be trying to raise the First Amendment in his discipline as opposed to suing for a violation of his First Amendment rights. So if I had a copy of the complaint, might know a little bit more on that. Our friends up in Canada, Leduc, boy, they're still battling in the newspaper there. Los Angeles County firefighter, there's a reported threat of a lawsuit in Los Angeles County over a line of duty death. And
there's always a lawsuit in Los Angeles. I mean,
oh boy. And yeah, so but I think that's going to wrap it up. We've been going for almost 50 minutes here, so we don't want to belabor it any longer, but we'll see you again next week, and that'll do it for another